significant ruling, the Gujarat High Court has held that citizens have a right to know the rules and regulations under which they are denied the permission to hold peaceful protests. It added that refusal of the police to publicize such rules amounts to killing and smothering the very purpose of the Right to Information Act. Justice Biren Vaishnav observed, and I quote from the ruling here, "Right to Information Act was enacted with the spirit that the democracy requires an informed citizenry and transparency of information which are vital to its functioning, and also to contain corruption and to hold governments and their instrumentalities accountable to be governed." The High Court held that while the police authority is empowered to regulate the conduct of people assembling and taking out processions in accordance with the rules framed under Section 33 of the Gujarat Police Act, at the same time, it also mandated that such rules or orders be published as per Section 33 subsection 6 of the Act, and that both the provisions are required to be seen in context of the RTI Act. This order was passed in a 2020 petition filed by an Ahmedabad resident who in December 2019 had been denied permission to hold a peaceful assembly to protest the Citizenship Amendment Act, with the police citing grounds of law and order situation as well as traffic problems as reasons for denial for permission to protest. Subsequently, the petitioner had addressed an RTI request to the Ahmedabad City Police Commissioner requesting a copy of the complete rules framed under Section 33 Clause 1, Subclause O of the Gujarat Police Act, which pertains to regulating the conduct and the behavior or action of persons constituting assemblies and processions along the streets. The petitioner had also sought information as to whether the rejection of permission was so done under the framed rules or regulations. The petitioner had also apprised the High Court that in March 2020 she had received a reply that a request for information sought had been refused on the ground that the special branch which decides the procedure for assemblies and processions is exempted from such disclosure by way of a 2005 notification of the Gujarat government. Justice Biren Vaishnav held that the police cannot refuse to produce such rules or orders, and that the rules and orders framed under Section 33 of the Gujarat Police Act, which are held or under the control of the employees for discharging its functions, must be published on the website and made available and accessible to the general public. Quoting from the ruling here, "Not only is the police authority empowered to regulate such conduct of people assembling and taking out processions in accordance with the rules framed under Section 33 of the Act, but subsection 6 of Section 33 mandates publication of such rules or orders. These provisions have to be seen in light of certain provisions of the Right to Information Act of 2005. Reading the preamble of the Right to Information Act indicates that the Constitution of India has established a democratic republic. The High Court thus directed the Commissioner of Police of Ahmedabad to publish all the rules and orders framed under Section 33 of the Gujarat Police Act on the website in the manner that the same are made available and accessible to the public at large. Thank you. I'm Maratra for LiveLaw. Keep watching LiveLaw for more such updates.